Hello everyone. Today is July 21st, 2026. We are doing our third live with attorney Leyla Muallimzadeh. Welcome, Leyla.
Thank you so much. Happy to be here.
Thank you. So we would like to start with some important news regarding immigration law, and then after that we will start answering the questions from the audience. First of all, I want to talk about the H1B lottery, and I also want to mention that we received one of our clients' H1B approval just yesterday in about 15 business days, or
correct, yes.
In 15 business days without an RFE. And this particular approval was important because it was a part-time position.
Correct, yes.
Leyla, do you want to talk about the H1B lottery and what was the news this week about that?
So this week, USCIS announced that they have received enough petitions and have met the quota for the 2027 H1B fiscal year, which means that there won't, unfortunately, be a second lottery. So if a person was not selected and this was their last chance, everybody has to think about their backup plans.
Okay, did you expect that?
I actually did not. I actually thought there would be a second round just because of the new way that the wages were being calculated, and we had to add additional information to the I-129 data collection. And I actually thought that there might be a second lottery. So I guess it's good news.
Yes. So if I was in the lottery and I was not selected, what should I do now? Like, do you have any recommendations?
So if a person was in the lottery and if they were in F status, my suggestion would be before the new F1 rules go into effect on September 15th, they should look into day one CPT if that's an option, because they will need backup plans. And once the new F1 rules go into effect, my understanding is that if you already have a master's degree, generally if you apply for another program, it will not be approved. So this is something that people have to take into consideration right now and move fast before the September 15th deadline.
Definitely. So most of the applicants are generally F1 students. Correct. Applying for H1B. If they are not selected, yes, then they should do day one CPT. Your Correct. Recommendation is that. Is there any other avenue available to them?
There is. If they are eligible for an O1, maybe that's something that they should look into and see if they qualify for an O1. There's also a J1 research program, so maybe they should look into J1 research program. Again, that has to be done before the September 15th, 2028 deadline.
Definitely. And I also have another option. If they have the funds and before the September 30 deadline, they can do EB5 investment in a regional center and they can Correct. File adjustment of status yes. that way.
Also, if they qualify for E2, if they're part of a treaty country, maybe they can do investment and
they can do
for E2.
Okay, thank you so much. And there is a big news regarding the public charge rule. What do we know about that?
So right now, the public charge rule in effect is the one from December of 2022, which allows USCIS officers to look at benefits that the applicant has received, only cash benefits. The new rule gives them discretion to look at non-cash benefits as well, and not only look and see if the applicant has received it, but also if the applicant has applied for any means tested benefit. So even if you were denied but have applied for it, that is also something that they can consider. In addition, because it's for the public charge rule, it's a totality of circumstances. They look at your age, your education, your skills, your experience, but also now they can look into the fact that whether you received non-cash or cash benefits, or even applied for non-cash and cash benefits.
Okay, so I don't want to stress everyone out. So let's say if I am an asylum seeker, should I be worried about this public charge rule?
No, it won't apply to the humanitarian-based immigration. So if you're asylee, WAVA, U visa, it won't apply to those classes. It'll apply only to family-based and employment-based immigration.
Okay, and I guess the most vulnerable immigrants based on this rule will be the family-based applicants.
Yes.
Okay, so the 2022 rule that you mentioned was brought under Biden administration,
Correct.
I guess, and so the Trump administration will have more stricter rules.
Yes. They will have more discretion, and they can look at non-cash benefits, which is the major change. And as you know, there's going to be an update to the 485, which will ask, I believe, more questions about if you ever applied, were denied. So there's going to be a change to the forms as well.
Do we know when the new form will be published?
So it's effective September 18th. I would imagine sometime before that.
Okay, so everyone should apply if they can.
Yes.
For adjustment of status before September 18th.
Correct.
So this is very critical.
Yes.
Many immigrants should take note of that.
Especially if they've received non-cash benefits that they're worried about.
Can you specify any non-cash benefits? Do you have any
I believe
examples?
It's the health insurance.
Health insurance.
So before, if you received state-funded health insurance, it was not considered as part of the public charge. We're still waiting to get more clarification, and we will have to see if it will apply to state-funded insurance as well. Because some people, they come to the U.S., if they become pregnant, then they apply for those state-funded insurance, especially they give it to women that are pregnant. So before it didn't apply to that. So we have to see if it's going to apply to that or not. And if that's the case, suggestion is if you have a case, apply before September 18th, 2026.
Okay, we will have more clarification in the upcoming weeks. All right. Did we see a similar change during Trump's first term?
We did see new forms for the public charge rule, and we did see more discretion, but even in the first term, it did not apply to state-funded insurance. So we're waiting to see if it's going to apply to state-funded insurance this time around.
Okay, got it. All right, so there is another important issue concerning the students. What do we know and what's going to happen?
This is also very new. As you know, it just came out on Friday, July 17th. So historically, a student, when they would get admitted to the US, their I-94 would not have a specific expiration date. It would say DS, which meant duration of status, which meant that as long as the student was studying and maintaining F1 status, they could stay in the US, they could transfer their school, they could go to a different level. All they had to do was basically coordinate with the school international department, get a new I-20, and study. Now that's going to change. So the new rule is going to be that the students will have a specific end date. And that is usually the program end date under I-20, not to exceed 4 years. So if you're a student now being admitted and your program is going to end in May of 2028, let's say, you can no longer just apply to the school, get an I-20 and apply for an OPT. Your admission date is May 2028, and now you have to apply for an extension with USCIS to also along with your I-765 for your OPT.
Okay, so I think I saw many students doing their academic degrees here, spending maybe sometimes more than 10 years
Correct.
without ever applying to USCIS.
Correct.
Just getting an I-20 would be enough for them in the
Yes.
past. But now they have to apply for and get the approval from USCIS, and I guess it will be much more stricter, harder to get those
Yes.
benefits.
So they still have to get their I-20s. They still have to update the CVIS, but they also have to apply for the authorization to stay in the U.S. They have to apply to USCIS and apply for an extension of status. So let's say somebody's program end date is, as I said, May 2028, but they couldn't finish in time and they need an extension on that. You can no longer just get an I-20 and continue studying. You have to apply for an extension of status.
Yes, so I am also much more concerned about the students who are going to language schools. And I believe that there will be specific regulations applied to them. And I am also more concerned that because the language schools have shorter terms, so that they have to apply for renewals from USCIS. And I guess we will not be seeing students going to language schools for years.
Correct. And the reality is that, again, this is a new rule. It's considered a major change, and it's subject to the Congressional Review Act. So Congress has 60 days to make any changes, and we're going to have to wait and see if there's going to be any changes or not, or if this is going to be the final rule.
Okay, so many things will change. Do you have any practical advice to current students?
So another thing that's going to change with this rule is that the grace period is going to become shortened. So right now, students in F1 status, if they want to change their status, or if they want to leave the US, or if they want to continue in a different program at a different level, they have 60 days. They're going to change that to 30 days. Students that are already in the US will still be covered under the 60 days, but if they decide to leave the US and come back, they're going to get an I-94 that's going to have a fixed period, whatever their program end date is, and they're going to be subject to 30 days.
30 days.
So as long as they stay in the US, they still get 60 days. But if you leave and you come back, you're going to get the 30 days grace period. That's one thing. The other thing is that students that are here right now with a DS I-94 have to monitor their I-20s, because they don't have to get a new I-94, but now their expiration date of their I-94 is going to be the program end date on their I-20. And they have to make sure, if they want to apply for an OPT, that they submit an extension. Actually, until 6 months after the new rule, they don't have to apply for an extension, but 6 months after the new rule, they have to apply for an extension.
Okay, so students should not rely on the I-94 lookup website anymore.
Correct.
Then they should check their I-20's
Correct.
expiration dates.
Correct.
All right, thank you. And so there are also rumors about immigrant visas, and as the administration brought a 100K fee for H-1B applicants from consulates, they are also considering, I guess, 100K bond for immigrant visa applicants. What do we know about that? I know that there is not much news or government published criteria about that, but many respected press published some articles about it.
Is it true that I believe that there's litigation over this, and it's considered that it was legal to do so?
So there was a litigation about 100K H-1B fee, but since this is not published yet, it will very likely that it will face legal lawsuits. However, currently we don't have much information about it. But it is so shocking that if, let's say, if I am a US citizen and if I want to bring my spouse from overseas, I will have to deposit 100K bond until they get citizenship. And if they don't use any public benefits, I will get my money back. But this is so, I guess, unfair even to US citizens, because family unification will be much harder if it will go into effect, and if the judiciary allows it to go in effect. Okay, let's talk about good news right now. So what did we see yesterday about visa bulletin, and what category did progress?
Yes, the F2A category, which is spouse and children under 21 of permanent residents, has drastically progressed. So that's really good news, which means a visa number is now available for them to apply for their spouses and their children that are under 21.
Yes, so I guess in July, the final action date was January 1st, 2025. And in August, it will be July 22nd, 2026, which is close to 7 months of progression.
Yes.
This is great news. If my spouse is in the US and if they have already filed the I-485, then now they can expect adjudication hopefully shortly.
Correct.
And then if they are waiting outside, they can also get the consult interviews and then maybe adjudications or visa approvals shortly, unless they are from the 75 countries,
yes.
banned countries. All right, so I think we can start answering the questions. Let me take, so we have a few, more than a few questions. Okay, Baran Birden says, I filed mandamus for a long-pending F2A I-130. Shortly after USCIS scheduled a petitioner-only interview while my spouse remains abroad. Will the interview focus only on our relationship? So it is good that your mandamus worked, and I guess the case progresses. But I must say that I did not see much I-130 interviews when the beneficiary is outside of the US. Did you see any I-130 interviews prior?
I've heard of like maybe 2, and it was mainly focused on the petitioner and questions they had about the petitioner. So if somebody is being called in for an F2A I-130 interview, petitioner only, I would really look into their own immigration history and make sure that there are no red flags.
Okay, so if the petitioner has received their green card through another spouse, then they can be concerned. I also know Adam Walsh Act. Have you ever heard about it?
No.
So if the petitioner has been convicted of some certain crimes, they cannot petition for a family member by filing an I-130. It's another issue. I am just hoping that there is nothing serious about this, but it is definitely unusual. Can we say that?
Like one that I heard of was they had questions regarding the petitioner's other names used. So that was the reason why the interview was held. They just wanted to confirm other names used and something to that effect. So mainly it'll be something about the petitioner. It could be something as 2 birth dates used or other names used, or it could be something about criminal history.
Okay. So generally I-130 does not ask about beneficiaries' criminal history and stuff. So we can only think about that. This should be about petitioner. And do you think that they will ask questions about the validity or bona fides of the marriage?
I mean, they can. Not that they can't, but if there's only one person in the interview,
yes.
But I strongly suggest looking into immigration and criminal history, and also having an attorney accompany.
Okay. Thank you, Leila. He also asks, or could they also question my residence and ties to the US? If no decision comes afterward, can the existing mandamus case still help? So let me answer the second part. Yes, generally we do not withdraw mandamus lawsuits until after fully adjudication. So even if you receive the interview, it's not full adjudication, so you can keep the case, mandamus case, open. And regarding the first part, could they also question my residence and ties to the US? So
I don't believe they would question that at this stage. Usually that's at the stage when, in this case, the spouse is abroad. So usually that's at the stage when you submit an affidavit of support And part of that is that the petitioner has to be domiciled in the US. So at that stage, at the consulate, they can question whether the petitioner is domiciled in the US and their ties to the US. But if you think that might be a concern, you can take, if he's employed, he can take his employment letter. If he has a lease, he can take his lease. The purpose is to show that the intention is to remain and live in the US.
Yeah, and I also had more than a few cases where the petitioner was domiciled outside, but they did show their intention. Once once the visa is granted, they will move to the US as a family.
Yes.
Okay. Another question. I have a green card and an RTD, refugee travel document. So it looks like this person got their green card through an asylum petition. My girlfriend is in Turkey and has no US visa. I can't return to my home country. We want to get married. What can we do?
If they want to meet somewhere outside of Turkey and get married, any country that they get married according to the laws of that country is recognized in the US.
Yes.
Or if they don't want to get married, maybe meet outside and become eligible for, well, he's not a US citizen. So
not yet.
So the only option is, the only option is get married somewhere outside of Turkey.
Okay. Yeah, so I believe I had a client who got married in Georgia, for example.
I had one too.
Oh, really?
Yes.
Interesting.
Yes.
All right. So Jansu asks, since my priority date is now current, is there a possibility that USCIS could make a decision on my I-485 based solely on the submitted documents without scheduling an interview? So I must say that USCIS does schedule interview for most of applications right now, even for employment-based applications.
Yes.
So we do not know if this person's application is family-based or employment-based. If it is family-based, I would definitely expect an interview. But if it is employment-based,
even with my employment-based cases, I've seen interviews in the past year and a half. So in the previous administration, they were not conducting interviews for employment-based, but since this administration has been in the office, I'm seeing interviews.
Definitely.
Yeah.
Do you have any experience after memo F2A marriage-based I-485 interview sent for consular processing by USCIS? What does it say? Officer, maybe? Clerk? Could you please mention your experience after memo interviews? Clerk manner changes. I guess they want to say officers.
Yes.
Okay. So thankfully, we did not receive any negative decisions so far. And we have had a few cases pending, but those were approved during this time. And no interviews, were decided with a denial. And then none of our clients had to go through the consular processing after the memo. Do you have anything else?
So I'm trying to understand the question. So was this F2A marriage-based applied for an I-485, but then the interview was scheduled at a consulate as opposed to an
No, so they applied adjustment of status in the US, but they are concerned that based on this memo, the USCIS can use negative discretion, and then they have to go through the consular process.
Yeah, I have not seen any, yes.
Thankfully, no, not yet. Murat Verdiyev, my EAD has arrived, but I still don't have my SSN. Can I legally start working for a company without an SSN until I receive it?
I would say no.
You'd say no?
I would say no to that because technically they can't, I don't think they can even put you on payroll without a social security number.
So first of all, they need to do I-9 verification process.
Correct.
And for I-9, I think employment authorization document can be used, but it has to be along with the social security card.
Yes.
Yes. So either you should wait it, or you should schedule an appointment with Social Security Administration, fill out an SS5 form, and then get the social security number. All right, so Ahmet Dalkıç says, hello, could you please let me know what your law firm's asylum approval rate has been over the last 3 months? I would like to understand the recent success rate of your asylum cases. So it looks like this person is concerned about their asylum application because of the recent adjudication trends. I can say that definitely I've seen a few referrals to immigration court, which and those cases were strong, and I would expect an asylum grant. But we did receive asylum approvals as well, so it is hard to say what will happen to your case. And I also saw that, for example, in a few cases, I thought that those cases were not very strong, but still received approvals as well. So it is not foreseeable, in my opinion.
I mean, when it comes to immigration, these kind of questions are very hard to answer because it's very fact-specific and case-by-case, and the officer reviewing your case also makes a big difference. So even if you get 99 approvals, it doesn't mean that the 100th one is going to be approved.
Yes.
So I don't believe there's really rates can answer a question when it comes to immigration.
Definitely. I also want to mention that we do many mandamus cases for asylum seekers, and most of those cases we do not represent the clients for their underlying asylum applications because they know us from our federal court experience, and then even though they have a different asylum attorney, they come to us to do the mandamus lawsuit. So sometimes I do not know the strength of the underlying asylum application, but still we do receive adjudications after filing mandamus lawsuits. So mandamus lawsuits are going well, but I can definitely say that referral rates are increasing. And this is concerning, and I also published a Turkish video last week regarding the asylum, USCIS asylum office trends, that AILA, American Immigration Lawyers Association, sent us a document saying that they are seeing some critical problematic trends at the asylum interviews, and sometimes they just issue referral decisions even before the asylum interview. That is definitely concerning. All right, another question. Hello, my wife has a green card and is currently there while I am waiting in Turkey for the process to be completed. I received an email from USCIS confirming receipt of August 22, 2025. Is there a follow-up question? Yeah. So there is no question asked, I guess. Am I right?
Yeah, I don't see, unless it's further down.
Okay. So if your application, if the I-130 petition has been pending for about a year or 11 months now, I guess, it is completely normal. What do we see regarding the I-130 petitions?
The processing times are very long, especially in the F2A category.
Yes, and if the petitioner is a U.S. citizen, I think it is normal to see 15 months of processing times.
Yes.
And if they are green card holders, then it might be longer. I think our system shows the questions in duplicates. So let me see if we have any questions unanswered. Okay, another one. I filed my N400. I mistakenly answered no to question 15B because I misunderstood the question. I did not disclose 2 written warnings and paid a $50 New York City red light camera ticket. My driving records are clear and I have all records and payment receipts. What is the best way to correct this? Should I correct it during my interview or upload a written explanation to my USCIS account? Thanks. I think I remember this question. Do you remember this question from last week live or no?
No.
Maybe it was asked in another platform. So I would definitely correct it before the interview by uploading a statement and making an explanation. It is not it's not a big problem for your naturalization application, and you don't have to even provide them with the documents. Just the explanation is enough. But what do you think?
I agree with you, and I believe it's better to do it proactively and upload, and maybe even basically this form, the section of the form, that page that he had to say yes to, mark that yes, put amended on top, and upload it. And I would, if he has evidence in support of it, I would also update that just so that they can see, I would upload that just so that they can see everything was taken care of and there's no issues.
So there is no harm in uploading the citation or payment records.
Correct.
Showing that the fine is paid.
Paid, yes.
Yeah. And if I'm not mistaken, you don't have to upload the evidence unless the fine is more than $500.
Yeah.
But it is still in your best interest so that they don't issue an RFE or any other document. Interview will be in the Warfield office. Okay, I'm just skipping that because there is no question.
There is one underneath it, I believe. It's the same.
Oh.
I got I-131 travel document two times.
Is this the person who asked, yes, F2A petitioner-only interview?
Oh, okay.
Okay, so I think we answered that enough. Is there any other question from anybody else? So I guess I did not answer this one. Is USCIS going to schedule another biometrics for travel documents after change of service center? So we are seeing much more biometrics appointments scheduled, even though the applicants did give their biometrics just maybe last year or 2 years ago. But the administration now requires new biometrics in new applications.
Correct, yes.
I just received an email from a client saying that, oh, I was scheduled an interview, is it normal? Because everyone is scared of getting arrested or something. But this is just a rule. And for travel document, if the refugee travel document or the regular travel document application is receipted prior, you will not get another biometrics appointment just because in the middle the service center changes.
Yes.
So we receive those transfer notices all the time, and it is just standard procedure. I never saw another biometrics after that.
I have not either.
Okay. I think we have one more question and we can conclude the live after this one. So this person says, I had an interview in August 2025, and my case is still pending and in process in USCIS. Do you think I will have another interview before they approve my I-130, I-485, even my I-765 applications? So looks like it's a family-based green card application, and then I can confidently say that I-765 is not about or related to this interview, so it is not tied to that. You don't have to worry about that. But it looks like it's been 11 months and they have not issued a decision in your case. So if there are some red flags, they can issue an RFE or notice of intent to deny, or they can interview you for the second time. Those are normal processes. But if it is a marriage-based green card application, and if you believe that your marriage is genuine and not just for immigration benefits, I would definitely recommend filing a mandamus lawsuit to get an expedited decision, because this is unreasonable.
Especially when it comes to the 765, I'm surprised that they haven't even issued the 765.
Yeah, so it is kind of shocking. So if they had the interview in August 2025, so maybe the work authorization application has been pending for more than maybe 15, 16 months, right?
Correct, yes. Even if there's an issue with the marriage, they usually still issue the 765.
765, yes. So this is pretty unusual, I can say. Okay, we have another one. If someone has the option of doing either K1 or CR1 route, not married yet, but could happen quickly, and are from a non-travel ban country, which route will you recommend at this time? So, depending on the circumstances, definitely, some people prefer that they want to come earlier no matter what. So, if that is the case, I recommend them doing K1, because K1s in my experience were approved around 6-7 months. But for the I-130 petitions after marriage, as we mentioned before, they take 15 months.
Yes.
So if your spouse wants to be here earlier, definitely K1. But the K1 route is kind of more expensive because you have to file another application once you enter the US. What do you think, Leyla? Do I miss anything?
I agree with you. I agree these days with the long processing times on the I-130, K1 might be a better option. But there's also one more option, and that is if they want to do the I-130 and maybe do a K3.
Yeah, I just saw once one of my clients for whom I did just a mandamus. Even after K3, they did not adjudicate the application. So another law firm has helped with that. I never filed a K3 case before, and because I do file mandamus cases a lot, so if there is a prolonged time, I just file a mandamus. But can you talk about the K3 a little bit?
Yes, well, I've done K3 in the past, so it was years ago. The way it works is that you file the I-130, and once you have the receipt notice from the I-130, you can file a K3 stating that you prefer to come to the US and await adjudication of the I-130 in the US. So if the K3 is approved, then you come to the US, you wait for the I-130 to get approved, and then you file for an adjustment.
Oh, wow.
Yes, but if the I-130 is approved before your K3, then your K3 is moot.
So you just spent.
Yes, but it was working in the past. I would have to look at processing times. So if the processing times on the K3 is way shorter than the I-130s, I think at this point it still might make sense.
Oh, wow. How long ago was your case?
I want to say 2009.
2009?
Yes.
More than 15 years? Okay.
Don't want to age me.
All right. And then the other person says, I participated in a lawsuit. Okay, I guess they already filed the mandamus lawsuit, this person. Okay, and I think we have concluded all the questions. Thank you everyone for attending. We will be doing these live interviews every week at 2 p.m. on Tuesdays, and I hope this was helpful. Thank you so much for attending, Leyla.
Thank you.
Thank you, everyone. Bye-bye.
Bye-bye.